decision. Appeal against the decision to the Commission in the prescribed manner. So, now, on this argument that the two things are synonymous, that would then mean that this decision of the CEO is a decision of the Commission which must be appealed to the Commission. What is that? It's clear that this is a two-tier system that is designed by the law so that, and this is very important, because these things are not just put here for decoration. There is always an underlying philosophical or legal reason why this is so. Here, the underlying legal and philosophical reason is what we all know as lawyers as the duty to exhaust internal remedies. Or, if you like, the separation of powers. The law, and this has been said so many times in many cases, Batista, Kumalo, Zondi, and so on. The law, mindful of the...
Please proceed, Mr.
No, okay, thank you, my lady. The law, mindful that there are specialist bodies such as the IEC, prescribes, let's put it that way, prescribes that when a decision is made at the level, let's say, of the accounting officer, you must then refer that decision to the specialists, the commission, the commissioners. They look at that decision, and once, if you are not happy, even at this second stage, then you go to court. So there's an underlying rationale why the court insists that a decision of the electoral officer within 30 days must be referred to the commission. Of course, we know that after that happens, if you're still not happy, you then go to court. So that's the reason. And that reason cannot be circumvented on top of it by a party that knows that the reason for that and has actually exercised it as eloquently put by my learned friend, Mr. Mutau. So unless there can be some, and one cannot think of any, a way of going around the fact that this is not a decision, and on this we are all agreed, all sides. This is not a decision of the Commission, but a decision of the Chief Electoral Officer, which by the prescription of law needs to travel the road via the Commission before it can ever see the light of day before this court. Now, there's an issue, I think His Lordship, Mr. Justice Adams raised this, maybe indirectly, about whether or not the trademarks issue is before us here. Because is not before this court. If you ask that question in the other way, why was the ANC, on their version, go and inspect the documentation, then they would have found the letter of the 4th of August. Then that issue would have been formed part of their appeal, and it would have been dismissed or upheld or whatever. Now, they say, no, understatement of the year. The ANC says we could have been more diligent. We accept that. No, you were negligent and you neglected your duty to do what should be done. Regulation 7 of the regulations, members of the Honorable Court, makes it clear. Regulation 7.2 of the regulations says, the register of parties and a copy of every document lodged with the CEO for the purposes of the registration of a party or the renewal of the registration of a party, the changes in registered names, abbreviated names, distinguishing mark, and so on, shall be kept for inspection by the public at the party, I must then invoke Regulation 7.2 to go and inspect the documents, and they'll be given to me free of charge. The ANC failed to do this, and without any explanation, tell us that they only did it on the 7th of January. But this court must overlook all these things and give it a hearing.
The ANC didn't raise the issue of the name and the logo. Did I understand you correctly? Because my understanding of the appeal was that they specifically raised that in the letter. I may be misreading.
That they specifically?
They specifically raised this issue.
No. That's exactly what I'm saying. Yeah. I'm saying they only raised the issue of the logo and the trademark in that court.
In the appeal?
In the appeal,
in the
yes.
Commission, to the
yes,
commission.
Yes, the commission. That's what I'm saying. I'm saying they did not raise this complaint here.
Oh, I
yes.
see. Okay.
No, they did not raise in the commission appeal this issue about the fresh letter and what have you.
Notionally,
right,
out of the sequence. Forget about that. We're not interested in that anymore. We're now following a totally different path based on legality and ultra vires. And on the basis of that cause of action,